very warm welcome to everyone here with us today to our webinar, which is part of the IUCN World Commission on Environmental Law's webinar series titled The Transformative Power of Law Addressing Global Environmental Challenges. And what topic would be more suitable in this context than to have an expert discussion and a first reaction to the advisory opinion that was delivered yesterday by the International Tribunal on the Law of the Sea in Hamburg under the United Nations Convention on the Law of the Sea on states' obligations to address climate change and ocean acidification in response to a request by the Commission of Small Island States on Climate Change and International Law, COSIS. My name is Christina Voigt. I am the chair of the IUCN World Commission on Environmental Law and professor of law at the University of Oslo in Norway. And again, I would like to welcome you all. I'd like to start with three notes of thanks. First of all, a very big thanks goes to COSIS. Goes to COSIS for bringing this issue to the tribunal and for providing this legal forum with the possibility to elaborate on fundamental legal questions on the protection of the marine environment against the impacts of climate change and ocean acidification. And we are particularly happy to have with us here today Professor Nilufer Oral, who was a part of the COSIS legal team. My second round of thanks, and I have to admit that's even a bigger thanks, of course, goes to the IUCN WCL team that on a pro bono basis prepared the IUCN submission to ITLOS. Professor Cymie Payne, who is also with us here today, coordinated these efforts. And we also have with us several other members of the drafting and advisory team, Professor Davenport, Attorney Sherry Broder, and Professor David van der Zwaag. And on behalf of the World Commission on Environmental Law, I'd like to use this opportunity to thank you all very, very much for your time, for your energy, for your expertise that you put into this joint endeavor. My third round of thanks goes to the IUCN Secretariat, and in particular, the Director General, Dr. Gretel Aguilar, as well as other members of the Secretariat like Sabrina Nix and Nick, Minna Epps, Sandeep Gupta, for their support and for their trust in the work of WCL. And I'd also like to thank the Executive Officer of WCL, Roberto Koch, for organizing this webinar. What was delivered yesterday by the 21 judges of the International Tribunal of the on the Law of the Sea was truly remarkable. And I'd like to share very briefly 10 quick reasons for why I think this advisory opinion was remarkable. And it's supposed to be a gate opener for the discussion that we're going to have with our experts here today. First point is that the opinion was unanimous. There was no doubt, there was no separate opinion, there was no dissent. The entire court agreed. And I spoke with some of the judges yesterday after the announcement of the opinion, and they said that the subject matter of climate change brought together the idealist in the court and the realist in a joint understanding of how to interpret the provisions of the United Nations Convention on Law of the Sea. My second point is that I believe that the opinion has potentially far-reaching consequences. Consequences for the system of international law generally, about the need to harmonize and coordinate between different international treaties and between treaties and custom. The tribunal considered that subject to Article 293 of the Convention, the provisions of UNCLOS and external rules need to be interpreted consistently. External rules which the tribunal identified were those in the United Nations Framework Convention on Climate Change, the Kyoto Protocol, the Paris Agreement, MARPOL, the Chicago Convention, the Montreal Protocol, with the Kigali Amendment, as well as the CBD, and I think a couple of others as well. The tribunal called for those rules to be taken into account when interpreting the provisions of UNCLOS. They are not lex specialis. They do exist independently and they don't override UNCLOS, but they are important international rules and standards that do play a role when giving meaning to the terms of the convention. And as the tribunal came back to it time and time again, the most important of them being the Paris Agreement, which in the words of the tribunal is the primary international treaty addressing climate change. My third point is that the most central finding, I think, is that anthropogenic greenhouse gas emissions fall under the definition of pollution according to Article 194 of the Convention, both directly as gases, in this way as substance, and indirectly by causing heat as energy in the understanding of Article 1, paragraph 1.4 of the Convention. And this applies to any source of greenhouse gas emissions, whether they are land-based, whether they are vessel-based, whether they are atmospheric, any source. And this is huge, and this is important. My fourth point is that with that finding that greenhouse gas emissions are pollution, the gates were opened to identify the content of legal obligations under UNCLOS. Under Article 194, it is to take all necessary measures to prevent, reduce, and control pollution of the marine environment. Here, the tribunal comes back to the climate treaties and notes that the United Nations Framework Convention and the Paris Agreement as the primary legal instrument addressing the global problem of climate change are relevant in the interpretation and application of the convention. In particular, the temperature goal and the timeline for emission pathways, which the tribunal identified correctly as reaching net zero CO2 emissions by 2050, and it referred to the IPCC report many places in its opinion, are set out in the Paris Agreement, and they inform the content of necessary measures to be taken under Article 194, paragraph 1 of the Convention. My fifth point is that the tribunal went further and noted that the Paris Agreement does not require parties to reduce greenhouse gas emissions to any specific level according to a mandatory timeline, but leaves each party to determine its own national contributions. This might be a slight misreading of the Paris Agreement, and since the agreement does address certain parameters of what parties need to do in their NDCs, but in any case, in the view of the tribunal, these are separate agreements, as I mentioned already, and with separate sets of obligations. My sixth point is the nature of the obligations is, as we know from before, but the tribunal identified it and stressed that many times, is that these are obligations of due diligence, obligations of conduct, which in the view of the tribunal is a variable concept and is depending on particular circumstances. Tribunal considered several factors. These circumstances that identify what obligations, the due diligence obligations contain, scientific and technological information, relevant international rules and standards, the risk of harm, and the urgency involved. And it concluded that if we apply all these standards objectively to the challenge of greenhouse gas emissions, then the standard of due diligence should be set high. My seventh point is the issue of differentiation between different states and the issue of particular circumstances. The tribunal noted that due diligence may vary according to states' capabilities and available resources, and it says that the implementation of the due diligence requirements requires a state with greater capabilities and sufficient resources to do more than a state not so well placed. Nonetheless, implementing the obligation of due diligence requires even the latter state to do whatever it can in accordance with its capabilities and available resources to prevent, reduce, and control pollution. That's the core of the tribunal's findings on due diligence. My 8th point is that the tribunal then went on to assessing the issue of transboundary pollution in Article 194, paragraph 2, and concluded that the standard of due diligence under Article 194, second paragraph, should be even more stringent because of the transboundary nature of pollution and because of the effect to other states and to areas beyond national jurisdiction. My 9th point is one that I won't go into much detail, that it also went into addressing the specific sources of pollution, whether it's vessel-based, land-based, atmospheric pollution, Article 207, and interpreted it consistently with its finding under Article 194 with respect to due diligence and taking all necessary measures. It also went into great details on environmental impact assessment requirements, but I would assume that perhaps Cymie will come back to environmental impact assessment. No, maybe yes, because it made reference to the recently concluded but not yet in force BB&J agreement. And my final 10th point is, and it's a very interesting one, I think, is that the tribunal interpreted the more general obligation in Article 192 of UNCLOS in answering question B as one of an adaptation, primarily adaptation obligation to the impacts of climate change. It stated that the obligation under this provision has 2 distinct elements: the obligation to protect the marine environment and to avoid damage, and the obligation to preserve the marine environment, which entails maintaining ecosystem health and the natural balance of the marine environment, and the duty to restore degraded ecosystems. Here it included a reference to the Convention on Biological Diversity, or talking about the harmonization between different international treaties. And it also, in this context, analyzed the need to protect rare and fragile marine ecosystems under Article 194, paragraph 5. So all in all, I think it is, as I said in the beginning, a remarkable opinion. And I think it's perhaps the best that the tribunal could come up with. COSIS was very happy yesterday, was thrilled. I think they received the clarifications they asked the tribunal to give. We do have now a clear confirmation that the law of the sea contains due diligence obligations to address the threat of climate change, which complement the Paris Agreement in this regard. And we have in this way another legal basis to hold states to account to reduce greenhouse gas emissions to the level necessary to protect the marine environment. The repercussions of this opinion will be felt for many years and in many contexts to come, not least when the next round of advisory proceedings comes up in the context of the International Court of Justice in The Hague, which I'm sure will read the opinion that came out of Hamburg yesterday very, very diligently. And with that, it's my great pleasure to give the floor to the Deputy Chair of the World Commission on Environmental Law, Mr. Ayman Chakawi.
Thank you very much, Christina, for setting the scene very eloquently and precisely with those 10 points that I think are very helpful in helping to guide our conversations going forward. We have people connecting from across the world. As far as I'm aware, this is the very first, if not the first, among the very first international events taking place to discuss this important outcome. And in that context, I wanted to share with you not 10, but three short excerpts from the press, the international media, reflecting the three international languages of the IUCN that shows the level of interest there is also in the mainstream about this important topic. The first of which being from The Guardian that said, quote, states have legal duty to cut greenhouse emissions, says top maritime court. Wealthy states must cut emissions faster than their developing peers, court says in major step for climate justice, end of quote. Le Monde. Crise climatique, l'avis historique du Tribunal international du droit de la mer. Selon un avis consultatif de cette juridiction de l'ONU, les pays ont l'obligation de réduire leur émission de gaz à effet de serre afin de protéger l'environnement marin des méfaits du changement climatique. And finally, AFA, and apologies for my pronunciation in Spanish, Tribunal Internacional de Derechos del Mar, ONU, los países están obligados a reducir la contaminación del medio marino. So as you were saying, Christina, it is a remarkable opinion. Well, lucky us, we have a remarkable panel to discuss this remarkable opinion. And without further ado, I'm happy to give the floor to the first speaker. So the way this event will be structured, be a first round of reaction for this amazing panel, then providing them with a second opportunity to further react or to what they had said previously or to what each other would have said. In the meantime, all of you, the more than 130 participants that are connected, are invited to peruse the Q&A function to ask any question, make any comment that you may have, and we'll seize upon those at a later time for further reaction from this amazing panel that we are very lucky to have with us. So without further ado, Professor Cymie Payne, that was introduced by Christina, who teaches at the Rutgers University and is also, of course, the chair of the IUCN World Commission on Environmental Law's Ocean Law Specialist Group. She played a very important role in our engagement in this particular advisory opinion, as well in other fora, including BBNJ, as Christina was referring to previously. Cymie, the floor is yours. Thank you.
Thank you, Ayman. And I'd like to echo all the thanks that Christina extended to our IUCN colleagues, especially the Director General, Gretel Aguilar, for their support. Of course, Christina, in addition to being the chair of the World Commission on Environmental Law, was a valued member of the team, contributing her special insights on the Paris Agreement, which she helped to negotiate. There's one other member of the team, Boss Clerk, who can't be with us today, and Robin Churchill also contributed extraordinary assistance on this. So we miss them today, but it was just wonderful to work with such a brilliant group of lawyers over the course of preparing this, the written submission, and then the oral statement, which you can see on the Law of the Sea Tribunal website if you want to see us arguing. So I thought maybe I'd start out commenting on the broad lines of what the tribunal had to say about states' greenhouse gas and mitigation obligations, and really answering the question, does it answer the question of what does the Law of the Sea Convention require that can move us past the lethargy of unmet climate policy needs? And I wanted to read one thing from the tribunal that really struck me. Early in the opinion, it says that it concludes that climate change represents an existential threat and raises human rights concerns. And that sets the tone for going forward in this opinion. I'd say that the tribunal was both bold and conservative in the way it tackled this. It read the treaty straightforwardly, but it didn't flinch in saying, when states agreed to this text in 1982, it was very clear that this is how we needed to deal with pollution. They had a vision of pollution that reflected their understanding of the connectivity between land, atmosphere, and the marine environment. And that could have been daunting because this is the Law of the Sea Convention. It's not the Global Climate Convention. But they followed the text as they had to, where it led. They were very careful in their analysis. So it's a long opinion. It's 156 pages in English. And they also referred to the many participants. There was an extraordinary number of states that submitted statements. It was 34 states submitted written statements, a number of international organizations, in addition to IUCN, so that they had a really strong body of views to look at, to consider, as they were doing this interpretation of the treaty text. So I think those are all important background things to keep in mind. I was going to talk more about some of the specifics, but Christina already covered some of them. So I think one thing that struck me in being at the tribunal and also going through all the submissions was the extent this time to which developing states were contributing. And I was sort of checking a factual point, and I realized that Rwanda, a landlocked country, became a party to the convention. So there's now 168 countries plus the European Union that are parties to the convention. Rwanda submitted its statement to the tribunal in this case on the day it became a party. On the day the treaty came into force for it. So I think that is another aspect of this. You were really hearing the voices of nations around the world. And I guess I do want very much to hear from the other speakers. They include my immediate predecessors as co-chairs of the Ocean Law Specialist Group, David van der Zwag and Nilufer Oral. So I'm eager to hear from them. But just maybe one final comment on the obligations. So due diligence obligations are obligations of conduct, not result. There's no obligation that you have to stop all your greenhouse gas emissions like that because the treaty says so. However, the tribunal embedded its legal analysis in the science. It begins with a detailed discussion of what the Intergovernmental Panel on Climate Change had to say. And honestly, if you read that, you are prepared to want the tribunal to say something very powerful because the science is so strong. This is a tribunal that is very oriented towards the science. It deals with fisheries. It deals with the shape of the bottom of the ocean. It's very used to thinking in those terms. And so it reads the science and it understands how to link it to the law. So then as it goes through what the obligations are, even though some of the obligations may sound kind of general and they may not sound like they go beyond the sort of usual, utmost efforts, blah, blah, blah. The way the tribunal frames them is actually potentially much more concrete. And I'll leave it, some of my colleagues may want to draw that out more. There was one thing that I thought this is, although the tribunal does not say this, the place they get the most concrete in a way is that in the context of talking about the scientific basis for understanding and of what's happening, describing what's happening with climate change in the ocean, they actually have a quote, it's a paragraph from a recent IPCC report giving specific steps that countries can take. Now, the tribunal doesn't say, oh, you must do this because of the Law of the Sea Convention, but it's there. If a state wants to say, oh, how do I actually do these objectively judged obligations? Well, here's some.
Apologies, just checking in. I lost sound with Cymie. Am I the only one? Just checking in if I'm the only one suffering from this issue. I lost sound with that.
No, I could hear Cymie well.
Oh, okay, sorry, it was just me. Apologies for interrupting you, Cymie. Please continue. Apologies. Thank you.
No worries. And actually, I was just coming to my conclusion. I think, okay, one other point. I want to say it now because I want to make sure it gets on the table. It was something that we were particularly concerned with in the IUCN submission. It's a kind of a small point, but a potentially very important one. That when states are implementing their obligation to prevent, reduce, and control greenhouse gases, Article 195 of the convention says they must avoid transferring damage or hazards from one area to another, or transforming one type of pollution into another. So when we're thinking about climate change solutions, we have to be mindful that we're not causing other problems for the environment. And that would apply specifically to marine geoengineering, that we need to be careful. Maybe we need to go ahead and do these things, but we need to be very thoughtful in how we do them. So please, friends, I want to hear from you.
Thank you so much, Cymie, for your contributions that are already very rich, and indeed we look forward to the further remarks you'll be making later, as well as the others from the amazing, remarkable panel that we have today with us. Thank you for sharing with us this inspiring and powerful example as well of a particular party that showcased that is a very telling example of the commitment for this important work. Also getting in the table some important elements of concreteness as well, and I'm sure the other speakers will be building on your enlightening and very informative remarks. Thank you again. The next speaker is Attorney Sherry Broder from the University of Hawaii at Mānoa William S. Richardson School of Law. With the East West Center Pacific Islands Development Program, apologies. And we're talking about the importance of commitment. And I think Sherry, by connecting at a very difficult time for her showcases in a new manner, again, when I say difficult, it's in terms of time zone only, her commitment for this important issue. Thank you. The floor is yours, Sherry. Is it only me again? I'm not hearing her currently.
You need to unmute yourself. Thank you.
Please, unmute yourself. Yeah. Please go ahead.
Okay. Yeah, I was so excited when I saw the opinion. I just couldn't believe that we could get such a clear view of so many different things that have been the subject of great debate. And I like especially the way the court decided that greenhouse gases were marine pollution. You know, it didn't matter if they were gases created out on the ocean or land-based, but any kind of greenhouse gas from any source whatsoever would be considered marine pollution. And, you know, so often, you know, in discussions about the oceans, there's the excuse that it's land-based. It's not, you know, the pollution wasn't initiated or created out on the ocean. You know, here in Hawaii, we're very concerned, of course, about the dumping of radioactive water into the ocean in Fukushima. And so, you know, the discussion is always, well, where can you bring a lawsuit? Can you do anything about it? Is there any forum? And of course, the argument always is that because the dumping is from the land, even though it, you know, it affects the entire Pacific Ocean, and that there isn't a basis for jurisdiction at ITLOS, or there aren't arguments to be made under the Law of the Sea Convention. So I think that the reason I'm talking about that is because I think that this opinion is going to have far-reaching importance, and others are going to look at it in terms of the clear definition of duties and the clear standards that have been set forth to avoid marine pollution. I think these are going to be very significant legal principles that will be tools not only for greenhouse gases, but in other situations relating to marine pollution. My one big criticism of the decision, though, is that there's no, the court was very specific to avoid any discussion of liability and damages. And that's always been my great interest, is can people go around and pollute and not have any responsibility afterwards? And unfortunately, the way the system works is that people are making money, and that's why it's so hard to cut back on greenhouse gases. I mean, there's, you know, development and other things that are very, very important, but nonetheless, unless the cost of polluting is included in the activity, then the incentive to actually make progress and do something to reduce the pollution is not so great. And I think we can see that when we look around. I mean, the court, you know, referred frequently to the Paris Agreement and other agreements and conventions and treaties that relate to greenhouse gases. And there's always lots of talk about it and everything. But if we look at what's been happening even since the Paris Agreement, is no stopping of the release of greenhouse gases. And you know, all the data that they collect here in Hawaii and at Mauna Loa on the, you know, rise of carbon dioxide in the atmosphere shows, I mean, the chart is just going up all the time. So Paris Agreement or no Paris Agreement, there hasn't been a significant change in the rate of increasing greenhouse gases. I mean, I hope the opinion will have some real impact, because the provisions, you know, the discussion about the due diligence, the discussion about obligations is very strong. The standards set are strong, but if there's no teeth, which I consider liability and damages to be that, I worry, you know, how is it that we're going to come to a point where there is a change and the graph shows a decrease in greenhouse gases rather than a constant increase. You know, I think that there are discussions at international meetings, conferences on loss and damage, and there's been a big effort at the International Seabed Authority to have some kind of a system set up. I think it is a very complex, thorny question, because, you know, who's responsible? How are you going to prove that the greenhouse gases that are being emitted right now come from the United States or Canada or Singapore or wherever? How are we going to prove where they're from? Would it be some kind of a percentage? But nonetheless, I hope that I know we had a section in this brief, and I tried to advocate for including more argument on it. So I hope that we'll continue to push that issue in the future. So I'll turn the panel over to whoever's next after me.
Thank you very much, Sherry, for sharing with us your perspectives regarding the clear definitions, your views, your criticism regarding liabilities and damages, your hope for real impact coming out of this opinion, and the importance of teeth. So let us take another bite in this panel by moving to our next speaker. who of course is Dr. Nilufer Oral, who's a very well-known leader in our community, a member of the International Law Commission within the United Nations, also a member of the steering committee of the IUCN Work Commission Environmental Law, and has unparalleled, of course, understanding of the proceedings, and very keen and curious to hear her thoughts about the advisory opinion. Nilufer, the floor is yours. Thank you.
Well, dear Ayman, thank you for that extremely generous introduction. I'm really, delighted to be here with my very, very dear friends. I have known all of them for a long time. They're all outstanding experts in their fields, oceans, climate change. I have been almost a lifelong member of WCEL. So I'm always so happy to be here with IUCN and the World Commission of Environmental Law, and who have really, I think, did a tremendous job in their written statement, even though I'm a member of the COSIS team, but I will absolutely sing the praises of the fantastic IUCN team who did a tremendous job in the written statement, which clearly had influence, and also when they made their oral presentations. So I'm going to, this really, is truly a consequential opinion. And I know that there were a lot of naysayers at the beginning. Advisory opinion is just going to be, just some platitudes. There was that sense. And I'm so happy that the tribunal has spoken loudly and really has delivered. And I think I'm going to pick up on one thing that Christina said about for the judges. This is their legacy. It really is. And if you read Judge Kitashasari's separate declaration, he ends in paragraphs 36 and 37, quoting from Dante, the Inferno. It is always darkest just before the dawn. Even in the darkest places, we can find light if we only search for it. And in his very last sentence is expressing his immense gratitude to COSIS for having come to this tribunal to search for this light, to guide humankind in the right direction, to ensure the survival of present and future generations amid the onslaught of climate change. That's pretty powerful. And I think you really feel in this opinion that the tribunal understood the responsibility. And I agree that, given the parameters of the convention, international law, they did absolutely the best they could, and they brought tremendous clarity. Even though most states were saying, yes, of course, greenhouse gas is pollution, but we never had an authoritative statement, none. And now it's clear. And I agree with Christina, all your 10 points, this authoritative statement has tremendous legal consequences. It's going to trigger other international instruments, domestic laws. So it's very important. There's so much to be said about this opinion, but I will try and just highlight some things that, in addition to maybe, I don't want to repeat what has already been said, which I agree with very much. But so now, number one, Paris Agreement is the primary for climate change. But for me, it was very important always that the tribunal, made very clear that the obligations of UNCLOS stand on their own. Other instruments inform them. And of course, the 1.5 degrees centigrade target is very important. But the protection and preservation of the marine environment has its own standards. And I think that's very important. Secondly, or third, we have now an authoritative link between land-based sources of pollution that go to the atmosphere and into the ocean, causing deleterious harm, such as ocean acidification, not just pollution in that sense, but other harm to the marine environment, fragile ecosystems. This is quite important. because this means all activities, not just activities that directly, we talk about vessel source pollution. But now I think that when we talk about environmental impact assessments, very interesting, the scope of this will be delineated. It could be quite broad in terms of now states will have to examine all activities that emit. Of course, we're talking really about carbon dioxide into the atmosphere, and then we know how much is absorbed in the ocean. So we'll see how that is implemented, but I think that's quite significant. Also, a lot of references to the precautionary approach. Science was absolutely center, and I think the statement the court made about even if there is scientific uncertainty, measures have to be taken. Very high standard that has been set. And so also on adaptation, it's the first time now there's no adaptation in the convention, and I know IUCN and COSIS both highlighted adaptation, restoration, protection of biodiversity, these as measures, and the court was very clear, including ecosystem-based approach. So it was a very, I would say, conservation-oriented opinion as well, clearly. And lastly, I'm just going to respond a little bit to Sherry's concern. COSIS specifically didn't go into responsibility and liability. And in a sense, that may have left the tribunal a little more space. It doesn't mean that this will be the last advisory opinion request, but I think that was a strategic decision on their part. And we know from the previous advisory opinions, such as the on the IUU fishing, even though the tribunal did state the responsibility and liability, it didn't necessarily produce results. I have to say that. So, on the other hand, I think this decision will actually be effective in perhaps launching domestic cases, which have been very effective. You know, so I'm not as negative on this, I have to say. I think that I don't think the case is closed either, but they set out very clear obligations, and primary obligations that are violated will certainly engender responsibility and liability, but they just didn't address that directly. So I'll stop here because I want to hear from my other colleagues, but I think we can speak for a long time about this remarkable historic case. So thank you.
Thank you very much, Nilufer, for sharing with us power and poetry in addition to your expertise. And if I may bounce on the quote from Dante's Inferno that you share with us and take us from Dante's Inferno to Dante's Paradiso, and a little quote from a little spark may burst a flame, end of quote. And of course, I'm not saying that this particular opinion is a little spark, but you were talking about legacy, we're talking about impact, we're talking about an alternative link. So I think there's a lot of food for thought going forward. And to further unravel this, I'm very happy to invite our next speaker, Dr. Tara Davenport, who's co-head of Oceans Law and Policy at the Center for International Law at NUS. Tara, the floor is yours. Thank you.
Thank you very much, Ayman, and thank you as well to IUCN for giving me this opportunity. I was beyond thrilled to be part of this important effort. And I really learned so much from everyone in this process. So very grateful for this opportunity. Overall, I think I have to reiterate what everyone else said. It's I think a great opinion, and I think really continues the role of ITLOS and international courts and tribunals in developing environmental jurisprudence. And it was really a lot of it, I think it was more than we could ask for. I think that the things that really struck me, and I think everyone's mentioned it before, but maybe I will just quickly talk about what I think struck me the most, or what I found most interesting. One of the things that we had, we often in the team itself debated about was this idea of does UNCLOS require states to do more than what was required in the Paris Agreement? And I think that the tribunal has resoundingly said yes, right? That the obligations under the Law of the Sea Convention cannot be satisfied by simply complying with the obligations and commitments under the Paris Agreement. And I think, and if states don't do that, international responsibility will be engaged. So I think that point was a very important point of clarification and affirmation on the importance of the Law of the Sea Convention, read in conjunction with the Paris Agreement, of course. The other point that I thought, the second point that I thought was also very interesting was this, the emphasis on common but differentiated responsibilities and respective capabilities. And I think listening to the presentations when we were in Hamburg, and there was much emphasis from the developing states on the CBDR principle. And I think they, you know, it was very interesting the way they didn't say, okay, the CBDR principle is a principle of international law and we can interpret the Law of the Sea Convention in light of the CBDR principle. They actually said, okay, the CBDR principle, CBDR-RC principle is not mentioned in the relevant provisions of the Law of the Sea Convention, but contains elements common to it, right? So I thought that was very interesting, but they were also, they made it very clear that of course developed states have to take the lead, but this does not exempt developing states from taking necessary actions within their capabilities. And I think this builds upon what the Seabed Disputes Chamber found in the 2011 advisory opinion. And, you know, this idea that, you know, even if you are a developing state, it does not excuse you from responsibilities, but also this idea of this question on what in the Law of the Sea Convention, we don't have, I guess, clear definitions of what is a developed state versus a developing state. And in the Seabed Disputes Chamber opinion, they talked about actually looking at the actual competence or capabilities of each individual state to decide on whether this, you know, the comment about differentiated responsibility should apply. So I think this also clarification is very important, or confirmation, right? That developing states, of course, they require technical assistance, but at the same time, they are not exempted from their obligations under the Law of the Sea Convention. The last, well, maybe the second last thing I wanted to say was on the due diligence. And I think this is also something we grappled with. This idea of the, you know, the debate or the distinction between obligations of result and obligations of conduct. And I think that the tribunal actually handled it very well in terms of, and I think this is a point that we made in the statement and that Cymie was very clear to make as well, that due diligence is not a, you know, loose sort of lesser standard, right? It's a very stringent standard. And, you know, implementation may vary according to resources, but it does not depend largely on the discretion of a state. And I think this really is going to go a long way into dispelling this myth that due diligence is something that states can hide behind, right? And I think this is critical in the development of the nature of the obligation of due diligence. The last thing I wanted to talk about briefly was from a Law of the Sea perspective, and as a teacher of Law of the Sea, some of the I guess the terms that have always, when I try to explain to students what does generally accepted international rules and regulations mean, what is applicable international rules and standards, what is internationally agreed rules and standards. And, you know, you have that in textbooks, but you don't, this is now, we have an authoritative, as Nilufer said, ruling from the tribunal, right? I mean, of course, I wish they could have gone perhaps a little bit further, but, you know, generally accepted international rules and regulations means accepted by a sufficiently large number of states. So at least we know that. That is, you know, I presume ratified by a large number of states. Applicable international rules and standards, those are binding obligations. They have to be binding either by treaty or customary international law. And lastly, internationally agreed rules and standards, they don't have to be binding, and they encompass a broad range of norms, both binding and non-binding. And I think this was actually a very important contribution to Law of the Sea in general. And with that, I'll end.
Thank you very much for your own important contributions to this to this panel. Much appreciated, Sarah. Thank you for also speaking about CBDRC and the developed states taking the lead, but at the same time, developing states not being exempt from the obligations, reminding us that you can try to run, but you can't hide from due diligence, and the importance to go always a little further in this important agenda. Now I'm very happy to give the floor to Professor David van der Zwag, who's a Canada Researcher in Ocean Law and Governance and Marine and Environmental Law Institute at Dalhousie University, who will be speaking, I believe, with a ray of sunshine. I don't know if it's still on your face right now. The floor is yours. Please go ahead. Thank you.
Going last is not easy because a lot of comments have already been made, and people are probably losing energy. About over 150 people online, and you've heard a lot already. So I'm going to make my comments quite brief. First of all, I think as I read the opinion, I had really two moods. One was the positive moods that we've mostly talked about here. It's a great opinion on many fronts. Now, I just mentioned two fronts in particular. I think the number one really leap forward was to get past this lex specialis argument that somehow the law of the sea convention was trumped perhaps by climate change, and that you didn't have to do more on the law of the sea than you would have under the Paris Agreement, the climate change regime. They rejected that very clearly. And that is fundamental for a number of reasons. One is the horror stories we're seeing every day in the news, and it's not science anymore, it's human experience, wildfires, floods, hurricanes, tornadoes, all the extreme events that we've been seeing, and the science is all there to back it up. And that's at 1.1 degree centigrade rise in temperature, approximately where we're at now. So, you know, it's a non-brainer to me how we can say 1.5 is a really safe, you know, guardrail. It's not. And even the 1.5 we know is not really a safe guardrail. We know that coral reefs will degrade somewhere between 70 and 90% further under the 1.5 degrees scenario above pre-industrial levels. And 2 degrees, you're looking at over 99% a loss of coral. So it's a climate emergency. And thank goodness the tribunal woke up to it and said, enough is enough. We're putting to rest this argument of what is the trumping aspect that could happen here. The other reason why it's so important, I'll give you an example of Canada. Canada made an intervention to the tribunal written statement. They started out by saying our Arctic is warming 4 times faster than the rest of the world. Our indigenous people are facing cultural, you know, subsistence issues and loss of lifestyles. All those things are up front. And what do they do at the end? They say, oh, by the way, they kind of come up with the lex specialis argument that we don't think we have to do anything more through external than, you know, than what's in external agreements like the climate change. So again, I think it puts to rest in for Canada the argument that I didn't think they would make, but they did, and many other countries did. So it put to rest that whole issue. The other thing I think was very important, besides what had been said, is that the also picked up with Article 197 about the international cooperation duties to further develop international rules, standards, recommended practices, and also to actually revise and continue to rethink where we are with treaty regimes and maybe the need for new treaties, new revisions. So they put that as a continuing effort that's needed. And I think that's very important because we all know that a tribunal cannot change the world by judicial fiat. It's going to take state practice. It's going to take a lot of international organizations, regional and global, to make the changes. So they put that on the agenda saying, you know, it's now a continuing duty, both globally and regionally. Very important. The last thing I want to do is just go to the other mood that when I went through, it came to me, a mood of a bit of sadness, depression, disappointment, frustration. So I'm going to give 5 downers that I see in the agreement. We've been pretty positive to date. First of all, note explicit discussion of international human rights, including indigenous rights instruments and documents, and their relationship to UNCLOS pollution and marine environmental protection obligations. Interestingly, the 3 UN human rights rapporteurs gave a amicus curiae brief arguing human rights and what it meant to this whole case. They weren't referred to. We did see some discussion of the considerable discussion regarding the comment with differentiated responsibility and respective capabilities principle, which is very important to environmental justice. So it did come in there. But one would expect, I think, at least to have some consideration by or explanation by the tribunal why they didn't really go more into human rights. And it probably is they just think it was under their mandate to actually go into that whole topic under the way they were given the instructions. But look what they did with liability. Look what they did for the whole maritime entitlements of sea level rise. Will it change the baselines? They said that's off our agenda because it's not part of our expected advisory opinion. But they didn't do that for human rights for whatever reason. So I thought that was a major limitation. Judge Pawak, after you go on the separate declaration, actually picks that up, saying what happened to human rights, what happened to environmental justice, all kinds of other decisions ready from European Court of Human Rights, etc. Where is that jurisprudence? It doesn't come into this opinion. The second downer, you might say, is the limited guidance on status and conduct, expected conduct related to the precautionary approach. So they do talk about precautionary approach quite a few places, and particularly they talk about it in paragraph 213 in relation to determining measures required to address marine pollution from greenhouse gas emissions. And the tribunal noted the absence of scientific certainty. States must apply a precautionary approach in regulating marine pollution from greenhouse gas emissions. And so, in the court went on to say, given the serious irreversible damage that may be caused to the marine environment from greenhouse gas emissions, precautionary approach is all the more necessary. And then they went on and they went back to their seabed disputes chamber decision on seabed mining and said, again, they kind of reviewed the text. There's a trend towards considering the precautionary approach as customary national law. They didn't make any declaration on that. So they just went back to what they had said before. And they did talk about the need for precautionary approach, ecosystem approach, and managing living resources in light of climate change at both the national level and international level. So there was some useful discussion there. And I guess the final thing I'll say about the precautionary approach, I was surprised that the tribunal didn't make any reference to what the climate change regime deals with precautionary approach. Article 3 of the UN Framework Convention on Climate Change calls for precautionary measures, of course, cost-effective precautionary measures, right? So they didn't get into that debate, and they didn't deal with the whole Paris Agreement kind of lack of explicit call for precautionary approach. But again, I thought there might have been some cross-referencing there. The third kind of downer I saw, a major limitation, is the minimal addressing of geoengineering, marine geoengineering, which has already been mentioned. They gave it short shrift. There's a paragraph 231 you'll see in the opinion. He said Article 195 provides duty not to transfer one type of pollution into another, which Cymie has already mentioned. Article 196 states have obligation to take all necessary measures to prevent, reduce, control pollution from and use of technologies under their jurisdiction or control. And then the tribunal said, it's already being discussed under the London Protocol, and it also being discussed under the CBD, but they never got into any kind of details. So I think there's a missed opportunity to tell the world that, wait a minute, we're in trouble here. We're now over 1,700 projects have been proposed, planned, or ongoing on marine geoengineering. This is no longer fairy tales, folks. This is real, it's coming. And so we have to wake up. And if you look at under the London Protocol, the 2013 amendment, which was trying to limit ocean fertilization to legitimate scientific research, subject to strict environmental assessment, that amendment was only accepted as of a week ago or so by 6 countries, still not in force. And under the London Protocol, we still don't have agreement on additional measures that maybe have to be put under that additional provisions, control under the London Protocol, such as ocean cloud brightening, the whole sequestration of seabed, into the seabed of biological waste matter. For example, macroalgae. In Iceland, they're actually taking large logs and taking them out into the ocean, start dumping them, sinking them into the ocean now to sequester carbon dioxide. So this is all coming. So unfortunately, the tribunal didn't really go into the kind of details. And it also did not look at what the climate change regime says about geoengineering. There's quite a bit of scholarship now that, in fact, under the Paris Agreement, UNFCCC, that maybe geoengineering is not acceptable in terms of the whole objectives of the Paris Agreement and UNFCCC. For example, even the Framework Convention on Climate Change talks about trying to make sure that we stabilize greenhouse gases within a time frame to allow systems to adapt naturally, not by international interferences through different projects. The fourth kind of downer is leaving considerable uncertainties over the requirements under Article 194.5 to take necessary precautionary measures to protect and preserve rare or fragile ecosystems and the habitat of depleted, threatened, or endangered species. You'll see quite a bit of discussion there about how we identify these. It's left very open-ended in terms of these rare and fragile areas. It's a case by case. When we look at these whole endangered, threatened species and habitats, again, they refer to CITES and the Commission on International Trade in Endangered Species and its appendices. But again, what about the IUCN Red List? What about Commission on Migratory Species and their listings? And then how do you protect them? They talk about special measures may be required, but then they get into all kinds of discretion that may be allowed, and it's left very open-ended in terms of what those special measures may be. They do talk about objective approach needed based on available science. And then the final point I want to make is just limited addressing area-based management measures related to MPAs and other effective area-based conservation measures. You only get 4 paragraphs towards the end on this topic. And some honorable mention, thank goodness, the BBNJ agreement, biological diversity beyond national jurisdiction, but no specific discussion of the Convention on Biological Diversity and its many important steps forward in trying to deal with the MPAs and other effective area-based measures. For example, the Kunming Montreal Global Biodiversity Framework, no mention of that. Target 3, 30% protect areas by 2030. And no mention of the EPSA process, the ecologically or biologically significant marine areas, where we have over 330 now EPSAs identified under the CBD around the world, and yet they're not really, in many cases, protected because CBD doesn't have the authority to protect it. So I think there are missed opportunities there, and I'll stop there because we do want some conversation, some discussion. One last thing I'll say, though, is that I have doubts that the opinion will have major impacts in some areas. And I talk about the article, I've done a lot of my work. Only 2 Arctic ocean states gave written opinions, Canada and Norway. They were quite limited opinions. And as you probably know, in the Ukraine war, the Arctic Council, the main forum, has now put pretty well a pause on a lot of the cooperation. So again, there are major problems when you look at implementation. We have to keep that in mind as we go down the road. I'll stop there. Thank you.
Thank you. Thank you very much for bringing in the important 1.1, 1.5 not being a safe guardrail, the importance of a continuing effort needed at the global and the regional levels, the 5 downers and the doubts as well, but at the same time, really basing those on a very keen understanding and reading of this important advisory opinion. Thank you very much for sharing that with us. Much appreciated. At this point, we have about 25 minutes left. So what we'll do, several of you participants were very engaged. Well, all of you are very engaged, but some of you shared in the Q&A some remarks and questions. So what I'll be doing now is referring to those, bringing those to the attention of our remarkable panel. Invite them to react to those, but also to the comments they would have heard from the other panelists. So in the order in which they were sent, first we have Joe Richard, who's very interested in the panel's views and comments on EIA, specifically on the impact of paragraph 365. For those of you that have the AO open, it is on page 123. And to what extent do we see this opening the door to Scope 3 emission to be included in EIA? Then we have Nora Ibrahim, who's very interested about the issue of sea level rise and worried about SIDS that may lose their territory because of sea level rise. And to what extent, how do we perceive and understand baselines, fixed baselines in that regard? Mario Sainz wants to better understand how this particular advisory opinion inform other potentially advisory opinions, particularly when it comes to the Inter-American Court on Human Rights and the ICJ, specifically when it comes to the engagement and participation of developing countries. Ayub Omar Dada expresses his appreciation for this panel, and then refers to yes, something that was discussed by several of you, the panelists, the extent to which, by falling under the legal definition of pollution, anthropogenic greenhouse gas emissions are subject to the framework and authority established by ITLOS to address environmental damage, and therefore, in the coming decades, how might the ITLOS framework be further utilized to address this issue? Anne Ellefson is interested about the potential legal impact of the decision on the BBNJ treaty. I'm assuming that Cymie in particular would be interested in that one. Amit Singh asks how effective the impacts are going to be from the viewpoint of the specific obligation to prevent, reduce, and control pollution of all kinds, specifically when it comes to due diligence that was discussed by several of the panelists, and keeping into account their obligations under relevant external regimes. Alman Salvaryan is interested in the views of the panel when it comes to paragraph 220 to 224 of the opinion, when it comes to the tribunal stating that it does not consider that the obligation under Article 194 would be satisfied simply by complying with the obligation and commitment in the Paris Agreement. There was also something that was touched upon by several of you, and according to Armand's read of this, the potential role of Article 31(3)(c) of VCLT paragraph 128 to 130, according to Armand, does not seem to have been applied in that regard, and whether separate obligation under the UNCLOS do not render more difficult for state parties to determine with precision the obligations of the marine environment regarding the specific issue of climate change mitigation. And finally, when it comes to Armand's questions, whether the tribunal gave any complete description of Article 4.3 of the Paris Agreement, individual obligation of conduct in paragraph 222 of the AO, stating that the Paris Agreement leaves to each party to determine its own national contribution. And I think that connects to some of the comments that Christina was making, for example, in her opening remark. Then Stephanie Prufa is curious to hear the views of the panel when it comes to the role of IGOs and NGOs for the development of the advisory opinion. To what extent was that involvement different from how these entities were engaged in ITLOS proceedings in the past, and how potentially the engagement and participation of NGOs and IGOs need to be altered or improved going forward. Very much connecting to what was just said on human rights, we have a question about the incorporation of human rights into the AO, and also Emmett Singh, who had made a previous question, is asking about the precautionary approach, and both of them were touched upon just now by David. Marie-Claire, our dear friend Marie-Claire, Professor Marie-Claire Kodeli-Sega, expresses appreciation for this event. Also, I think an anonymous attendee wants to react on the CBDRC, and I think specifically to Tara's intervention about to what extent CBDRC is a principle of customary international law, and what would be the implication of this AO when it comes to how CBDRC is to be viewed as a principle of customary international law. Ahmed Ali Shariati is asking about the attribution of responsibility for emissions, the extent to which the impact of environmental pollution. Rasid Tariq is also asking about the rights and lives of indigenous coastal people, and I think David, in one of his 5 downers, was also referring to that. Another question about the legacy of this advisory opinion, to what extent it will be helpful, and what is its legal bindingness. Ellen Robock is asking about the impact specifically on the United States of America. Meg Bowman is asking about the panel's opinion regarding potential cascading impacts of these advisory opinions on private sector firms and business as usual. And finally, Professor Zuneida Musa Wadiwala is expressing appreciation for this webinar. Thank you very much. Sorry for taking the time to read all of them, but we are very keen at the Commission to be as inclusive as we can be for these webinars. So now I'll be happy to give the floor back to Cymie for her reaction to some of those questions or to the comments that she had heard from the other members of this amazing panel. Thank you very much.
Thank you, Ayman. And also, I want to take the opportunity to say you've been a fantastic moderator in listening attentively and picking up on highlights from what we've each said. So thank you. I have not heard anything, I think, that I disagree with, or at least not strongly, from my colleagues. And it's been an enormous pleasure to be here with you today. I think I'm going to try to answer a couple of questions, maybe 3 questions, comprehensively. And so as to environmental impact assessment, impacts, or how this interplays with the BB&J agreement and the US position. And I also want to flag that Alan Roebuck is one of the outstanding scientists working on geoengineering issues with expertise in solar radiation management. So he's coming at this question from a deep understanding of some of these issues. I think there's 2 ways to think about the impact of an advisory opinion. One is it's not legally binding. We all realize that. However, it forecasts if a contentious case comes to the tribunal between states, it forecasts how the judges may rule. They want to be consistent. They aren't obliged, but they want to be consistent in their opinions. So it tells us something about what they consider to be legally binding. And in that context, some states, some governments take this very seriously. Some court systems will integrate this in their own jurisprudence. So that's one aspect of it. It's the legal aspect. The other way of understanding these opinions and their influence, and this is, in my view, as a student of international courts and tribunals, is the strongest influence of these courts and tribunals is the normative impact. That this is, as my colleagues have said today, this is an authoritative interpretation. This is a geographically representative group of judges. So they don't speak just on behalf of one nation. They're speaking in their independent capacity from a deep wealth of knowledge and experience. And there's a lot of gravitas to their opinion. So in that sense, it's very influential. So the United States is not a party to the convention, but it is an attentive observer. And it should be, I have to, as an American, underscore here that every administration, with the exception of one recent administration, has wanted to ratify the Law of the Sea Convention. It's been the US Senate's role in blocking it that's prevented us from joining. So there's a very strong, our executive branch has a very strong commitment to following the convention. And I think this will have some influence even in the United States. How it influences, so the Biodiversity Beyond National Jurisdiction Agreement, sometimes referred to inappropriately as the High Seas Treaty, is just being signed. It's in the course where countries are beginning to ratify it. We're hoping it'll come into force next year. And it has, it embodies the cooperation that the Law of the Sea Convention calls for and that the advisory opinion highlights. So it is a means for implementing this. It also includes specifically environmental impact assessment obligations that are described here. And it was very important and valuable for EIA practice, environmental impact assessment practice, that the tribunal says that cumulative impacts are part of that. And there's some very good language there, which you should take a look at. I think that kind of, the scope 3, the question about scope 3 emissions. So this is where you really need to look at each context. So I just mentioned how this might influence BB&J. Scope 3 emissions, as people may know, are the kind of down the pipe impacts of, Scope 3 emissions on fossil fuels are people driving cars. So it gets pretty remote from the source. And it's very difficult. Cumulative impacts are technically difficult to address, but it's being done. Scope 3 emissions are even more challenging. So I think you really have to look at the context, and that may be a bit beyond the scope of this opinion, though others may have different views. So thank you again for this opportunity and for the great question.
Thank you very much for keeping us in scope as well. Thank you, Cymie. So now I'm happy to give the floor to Sherry for any additional remarks, reactions she may have. Thank you.
Unmute yourself.
Yeah, sorry. I appreciated the question on whether or not this opinion was going to change business as usual. And, considering that I don't think there's any question, but climate change is an existential threat. And this past few years have really shown how dramatic the change in weather and extreme events has been. And, I just don't know where we're going or what's going to happen. The opinion refers to a lot of treaties and conventions, agreements that have been entered into and relate to climate change. And still, as I said earlier, all we're seeing is, despite all of these good efforts, it is business as usual, and the greenhouse gas emissions are only increasing. So I don't know. I mean, I love the opinion, even though it didn't have my favorite topic in it. And I think that it's wonderful to see the development of the law in this way, and to have an international court take a strong position on states' obligations. But at the end of the day, is it going to, is it strong enough to make a difference? And really, are states what are states going to do in terms of really making a difference in what is happening? So I guess I can't answer that question business as usual in an optimistic way. I have to give a pessimistic answer as I look at the conduct of states and corporations as we've moved forward. I do think that the environmental impact statement is one tool that might help in terms of making and decision making. I think the court tried to be very broad in terms of what was going to be required for environmental impact statements, when and how much, and what was going to be required to be analyzed. So, perhaps that will end up being a very useful tool in evaluating whether or not projects will go ahead or matters will go ahead. But at the same time, does that now cover how many cars you allow in your country? Do you have to do an environmental impact assessment if you're going to have cars that are based in part on petroleum to run? Is an environmental impact assessment going to be required? Or if not, then, well, there's a great source of emission of greenhouse gases. So then what's the value of the environmental impact assessment if we're not going to require them for cars or the numbers of cars that are being put on the roads? So I like that David had 5 points of criticism or disappointment or whatever you call them, because I think I'm looking to have a better answer to the person who asked the question. Is this just going to be business as usual at the end of the day? Next up. Nilufer.
Thank you. Thank you very much. David's 5 down have turned into 6 at this point. But thank you again, of course, for reminding us that there is no question that climate change is an existential threat. Thank you very much. Nilufer, I suspect you will be particularly interested in Nora's question about baselines and SIT and sea level rise. Thank you.
Yeah, I do. But I also want to take a more positive outlook. I don't want us to leave the negative sense. This is really a landmark decision. Yes, I know. States, business as usual, but I think we still have to. This is a great tool that's been given to us, and to use what we can as lawyers to implement it, challenge the businesses. Without this, there's nothing. And I think now there's something, and that's something to really, we'll never get everything we want from these decisions. It's a tribunal, but I think they gave as much as they could. So I want to keep a positive outlook, because negativity is not going to get us. We need to really move forward. And it's very easy, and I agree, it's very easy to become despondent. But I'm going to go on to a topic of direct interest. To me, because of my work at the Commission on sea level rise. And we have, so it's a commission for the International Law Commission. And I'm one of the co-chairs of a study group on sea level rise in relation to international law. We have been working on issues such as baselines, maritime zones, the impacts of sea level rise, as well as other related issues, human rights, statehood issues. And I think this was not brought up. I mean, some states raised this issue to the tribunal, but COSIS did not. This was really focused on these 2 issues. And partly it's important to know that the UN is already has a process going. And one thing to ask the tribunal to take a position on something when that process is moving forward strategically is not a good way. And we know that right now in the commission, the 6th committee, which is part of the General Assembly, we're seeing a lot of forward positive movement towards recognizing the importance of preserving existing lawful rights. So, and that is something that particularly the Pacific Island states have been extremely vocal in and have really played a very important role. And so right when you have a positive momentum going and states, and they're the key actors, you want states to be taking ownership of that, it would be a bit, it may be not the right moment to bring this issue to the tribunal. So it was not brought, but I have to tell you that within the UN, the International Law Commission, the General Assembly, I feel that we're making very good progress, where states are acknowledging the importance of the notion of preserving existing maritime entitlements in face of sea level rise, particularly for small island developing states who rely heavily on these, important ocean resources. So I'll just stop there. I can go on, but that's in a different forum, and it wasn't raised with the court by COSIS.
Thank you very much for that, Nilufer. I would like to bring our collective attention to the fact that unfortunately we cannot address the questions that were added in the Q&A for the interest of time. However, I'm seeing, for example, that Cymie is directly replying to a reaction from a representative of Global Choices, and also I see a question from Abdul Hafez Hama. So if you'd like, as an expert to panelists, to directly reply in writing, that's all then welcome, but we won't be reading them out the same way we did for the previous questions in the interest of time. I'd now like to move to hearing from Tara, her reactions at this stage. Thank you.
Thank you. And I realize that we're very short on time, so I will try to keep my points very brief. In relation to the question on the development of the CBDR-RC principle in customer international law, I'm not sure. I don't think it really will, but I found it interesting because I think in the climate change context, in contrast to the climate change context and the law of the sea context, we don't have that much discussion on the CBDR-RC principle. Of course, the Law of the Sea Convention was adopted in 1982, very early on. So I think it is very significant that even though it's not specifically mentioned in the Law of the Sea Convention, that courts and tribunals are interpreting it to place obligations on developed states for technical assistance, as well as emphasizing that developing countries are not exempt from the obligations under the Law of the Sea Convention. So I think that is a very significant development, building on the jurisprudence of the Seabed Disputes Chamber. The second point I wanted to talk about was the advisory opinion did not make any contribution on attribution, but it did acknowledge explicitly that developed states have played a more significant role in contributing to GHG emissions. And it also said that causation is separate from the application of obligations. So I think that was also a notable development. And lastly, I think in line with what Nilufer, who is also my boss, said in terms of being positive, I think we tend to look at, the role of international courts and tribunals as focused on compliance, on, if states don't comply with this particular judgment or decision, international law is ineffective. But I think we have to look beyond that, right? This idea, the process itself, so many states participated. They were forced to engage in what the nature of their obligations were in relation to climate change. Right, the advisory opinion brought so much clarification and certainty, which we did not have before. States can use it as leverage in discussions in any other forum, and I think slowly but surely it will play a significant role in shaping state conduct in this respect. And with that, I'll end.
Thank you very much, Tara, for putting so much content in quite a short intervention.
2 minutes.
Thank you very much. Very well done. Thank you. Now I move to David. David, the floor is yours. Quite a few of the comments from the participants were in connection to some of the points you raised.
Yeah, a lot of questions, so I can't go into every one. And maybe I'll just end up with kind of being on a positive note if I was too negative. I really do think that decision is so important because it really does tell countries now that you may have to do more than under the Paris Agreement, UN Framework on Climate Change to deal with these problems of greenhouse gas emissions and adaptation. So that's an important message, a fundamental message. And so now it's pretty clear. Also going back to Article 192, and then also Article 194.5 with protecting and preserving these fragile ecosystem areas and habitats of threatened species. Again, that's very important. And the tribunal is very clear. What that means is at both the national level, international level, we have to move forward on making sure we have adaptive living resource management in fisheries, for example, aquaculture as well. And we have to apply precautionary ecosystem approaches. So again, they kind of put the bar up again further in terms of how we deal with climate change and relating to living resources. Very important steps forward. Again, it's kind of business as usual because these messages have been out there before, and regional fishery management organizations have not been listening very well overall, trying to deal with climate change. But nevertheless, perhaps gives a renewed emphasis to the need to move forward. Let's say the question of other opinions, what may be its impact, remains to be seen. I think it probably will have some impact. I would think International Court of Justice, for example, could refer to it in terms of law of the sea findings, perhaps the due diligence findings. Of course, the Tribunal on Law of the Sea did not deal with human rights. So there's a huge area there that probably could be filled in by other courts and tribunals. And hopefully the ICJ advisory opinion will go further related to multilateral environmental agreements, for example, like the CBD, what its role is, CMS, Convention on Migratory Species. There might be more done there in further opinions that come forward. So I'll stop there and thanks to everyone.
Thank you very much. And clearly, there's a lot of appetite for sharing more and more and more in the context of this important advisory opinion. However, unfortunately, the time has come for us to close this first post-ITLOS AO on the request from the Commission of Small Island States on Climate Change and International Law International webinar. And to close us off, I'm happy to give the floor back to Professor Dr. Christina Voigt of the University of Oslo and the chair of the IUCN World Commission on Environmental Law. Thank you very much to all our panelists and to all the participants. Christina, the floor is yours.
Thank you so much, Ayman. And before I say the final word, I did want to end also on a positive note. I'm well aware that it's, you know, an advisory opinion can never be a silver bullet, and there are always some elements to criticize, and it's worthwhile criticizing them. But I think it's also very important to see the power that lies in that opinion, right? The potential that is there. To use it for our work, for our academic work, for our policy work, because it has some very concrete elements in it. Just think about what it means for state now to take all necessary measures to prevent, reduce, and address marine pollution. This is potentially so incredibly far-reaching that I think it might take some time for us to digest what really is the impact of that opinion. But I think it is what we make of it, right? If we use it as a powerful tool in our work, it will become powerful. If you criticize it, it may be less powerful. But it will also be something that will be very important to other international courts, which will come with their advisory opinions in the next couple of months and years. There was one question there on the ICJ and the Inter-American Court on Human Rights, which have parallel proceedings on some of the similar questions. And I think what we've got from the International Tribunal Law of the Sea, it's an authoritative interpretation of UNCLOS. And I really doubt that some of the other courts would say something else, at least when it comes to the Law of the Sea obligations. So here we really have something that set the tone in the context of the Law of the Sea. And I think it can be used as something that now really puts the pressure on states. States need to regulate private actors to have interventions that matter, to put private actors under a regulatory regime in line with what needs to be done to protect the marine environment. There is a rich bouquet of questions which I would burn to answer, but we don't have the time for that. But let me please close with thanking everyone in our audience for having been here with us today for 90+ minutes. It's a long time. It's a privilege to have you with us. But I also would like to thank our speakers, our distinguished experts who shared with us their takes, their first takes on that very fresh development from just yesterday. It's really fantastic that you were so sporty to just jump in and say, yes, we will read it and we will share our views. Thanks so much to you, Ayman, for your wonderful sharing and your very knowledgeable guidance to this discussion. And many thanks, of course, to Roberto in the background for making sure that everything runs smoothly. The webinar is recorded, has been recorded. It will be included on the WCL website for you to rehearse it if you want to. It is something that will go into our library on our website. And I would like to close with two more recognitions of legal giants in this field. One of them, David Freestone, who was in Hamburg yesterday, and we had a quick chat. He was involved in the very early rounds of WCL work on this, and I wanted to recognize his contribution. And of course, to the late Professor Alan Boyle, who would have been incredibly thrilled and touched and moved to see what came out yesterday from the International Tribunal of the Law of the Sea. It was his legacy, really, that got us there. And with that, have a nice day, everyone, or good night and good morning. And thanks again for having been with us.
And thank you, Christina.
Thank you.